That is, we don't expect...
The Court of Appeal have made concurrent findings of fact that, in fact, this person is not qualified. What is the level and standard of review expected of the Supreme Court in those kind of instances?
Yes, that's one case that I think the Supreme Court perhaps needs to look at because of the kind of criticism that has come as a result. And I think the dissenting opinion of the retired CJ to some of us makes more sense because he draws an analogy between the requirement to be elected as president of the
Finally,
nation,
our investment is hinged a lot on developing our legacy systems, evolving from the traditional legacy.
If any of those requirements are not met, then the candidate is not qualified to contest. And so if one of the requirements is this certificate that you ought to have, and two courts below have analyzed and assessed that evidence and are satisfied that that certificate is not there or has not been presented. Going by the decision in Munya, unless the Supreme Court is satisfied that the factual review by these two courts did not meet the threshold that they had set in Munya, is only then that it would reverse the factual finding.
Okay, thank you for that. The next question, and this will probably be my second last, is Article 43 of the Constitution protects economic and social rights. Can you just tell us why these rights are important? Number one, why they are important, and two, what challenges are there in terms of justiciability and enforcement of social and economic rights?
Oh, what a mouthful.
Okay, why are they important?
Yes,
why are they important, first and foremost?
I think the people of Kenya decided for the first time to give very elaborate rights, economic and social rights, because of the realization of the differences in the society, so as to provide for those who do not have and promote the growth of the economy. Why the justiciability? There haven't been very many such cases, perhaps because of perhaps the same reason, poverty. And therefore there have been very, very few. Again, going by the decisions and even the provisions in the Constitution, where all these rights depend on the government's ability to meet them, those perhaps are some of the challenges and reasons why they are few and in between.
Okay. And finally, this is a quote from Mr. Wanyoike on devolution, and he says that in many ways the Supreme Court has developed progressive jurisprudence on devolution, which seeks to protect county governments and help assert their constitutional space. Probably you would just give us one decision you think has satisfied these criteria of being progressive and supported the devolution. maybe one or two decisions you think have been important, and why?
The Council of Governors decision on division of revenue is one of them, because in that decision, it was settled how disputes between the two levels of parliament are to be resolved so as not to delay disbursement of funds to the counties. That's one. Again, I think the one for Embu, a decision emanating from Embu regarding the position of deputy governors, where there is no deputy governor, what happens? I think all that go to strengthen the evolution.
Okay. And finally, are you aware of the Maputo Protocol?
Yes, on the environment?
On the rights of women?
No, unless you jog my memory.
The Maputo Protocol is a protocol to the African Charter on People and Human Rights.
I'm aware.
So what is the purpose of that protocol? Just what is the purpose of the protocol? Maputo Protocol.
After the charter, I think there were two protocols. One, the one that created the court, and then the one that brought in the right of women, where it was emphasized that the right of women must be recognized. The practices that are harmful to women, things like FGM was discussed, the right to property, and also I can remember only those.
Okay, thank you very much, and wish you well.
Thank you, my Lord.
Thank you very much, Honorable Judge Machacha. Thank you, Your Honor, for those answers. Commissioner Basharia, please go ahead.
Okay. My Lord, I'll ask you very few questions. The first one is, I'm impressed by your humility, because you're one of the leading candidates for this position of CJ, and you've taken it in stride and with a lot of humility, which has kind of won me over. Now, and I would be interested in knowing, because this was an opportunity for others to learn. There are also students of law who are out there watching, the other Kenyans. What makes you like that, to be a humble person who is able to take, results of a situation in stride and move on, because it's something that lacks in many of us.
Thank you, Commissioner. Some of these things are very difficult to explain. They are just things that people are born with. Perhaps the upbringing, perhaps our training. So my humility, I can say that we are all humble in our family. So perhaps it's hereditary. Also, the upbringing to respect others and not to talk at the top of your voice. Really just upbringing in the family. So I really have no particular fact I can attribute to my humility, if I am.
And how do you use that quality? Because it's an important quality. All of us, lawyers, we have, like in your position, you understand the law. jurisprudence, one cannot say they'll challenge you on it because you've probably seen it all. But you'll find that when it comes to these other personal attributes, even the very brilliant, when they lack it, they are not useful to the society. So how would you use those attributes in the court that you're going to in the Supreme Court?
The same way I've used them as a magistrate, as an administrator in the judiciary and in the Court of Appeal, where you strive always to bring people together, to resolve conflicts, to be able to see other person's point of view, to be patient, to listen, and to be slow to talk back. Those are some of the attributes that I've used in my career, and if I'm honored to go to the apex court, the same attributes will not change.
Okay. Now, the other question is that, looking at your career, you started from the bottom, district magistrate to professional, as we used to call them. Now, you've grown through the ranks, Of course, on merit, you've earned all the way. There are many lawyers who would opt to go to private practice because it was easier to make money faster. There are those who sacrificed and decided to be in the judiciary, others, government, and others. Now you'll be going to the apex court, and it's the dream of every legal practitioner to end up, because that's the highest court. Whether it's in the US, whether it's UK, whether it's Kenya, that's the ultimate. Now, tell me, what is this impact? Because I don't want it just to be that umefika, that kind of like now you self-actualization, you've reached the apex. What is this impact? One single impact that you believe you'd want to make in that court now that you'll have reached more or less where every other person dreams to be in the legal profession?
Yeah, thank you, Counsel. Some of us joined the bench because we wanted to serve. There wasn't pay to talk about at the time we joined. And as you join the bench and ask any magistrate today what they aspire to be, when you join the bench and that's where you want to spend your time, you have not joined it for any other reason, your eye is on the topmost court and on the topmost job, the Chief Justice and the Supreme Court. And so it is the journey I have traveled. Excuse me. I've tried to do it on a very straight line, no cutting corners. And so should I be lucky to reach the top court, the way I have conducted my matters, the way I've related to colleagues is the same way that I will conduct my matters and relate to my colleagues. Specifically, my concern has always been access and expeditious delivery of judicial service. I know the Supreme Court doesn't have a backlog to talk about, but the focus, because we'll be working, God willing, as a team, is to ensure that the court becomes real time, to ensure that the pending matters, I know there are reasons why they have backlog in that court, the numbers and conflicts, some judges having had those appeals from the High Court, is to reduce that backlog by deliberate case management so that the court becomes real time, so that a matter filed this year is heard this year, the judges have enough time to do thorough work on the judgments and rulings that they produce. So the focus really is backlog reduction and expeditious disposal.
Okay, my final question. Next year we'll have the presidential elections. And you know how that is a big issue in this country. A lot of divisions, and actually our country is like we all become mad, you know. Now, and that court is very critical in keeping the country together. Now, for you, what assurance would you give to Kenyans that you'll also play your role, and how would you play to ensure that ultimately as a country, Kenya is the winner at all times, regardless of how situations unfold? How do you ensure that you are playing your rightful role in ensuring that ultimately Kenya is the winner?
We have seen divisions previously, and Kenyans are very quick in labeling judges whenever they make decisions, not just in the Supreme Court, but even in the other courts, labeling them to be supporters of certain political groupings, labeling them ethnically. And so as a judge, the oath that I take to defend the Constitution, to do justice without favor, affection, or ill will, is going to be the flag that I will carry. That it will not matter who or what. The bottom line is justice must be served to the best of my ability.
Thank you, my Lord, and I wish you well.
Thank you.
Oh, are you done, Commissioner? Oh, okay. Honorable Attorney General, this is your time to please engage the judge.
Thank you very much, Madam Chair. My Lord, good morning again.
Good morning. Morning.
Please allow me to take you back to the discussion we had where, in answer to a question by the Honorable Mr. Justice Wasame, when we spoke about perceptions in the Supreme Court. One of those perceptions, of which you're well aware, and it's constantly in the social media, are allegations of corruption and bribery. It keeps coming up time and again. Now, in the event that you find yourself being appointed to join that court, you'll be joining that court with that backdrop. As Judge number 7 in a collegial court which you're familiar with, how would you engage your colleagues from the President of the court, the Deputy and the other judges to address that particular problem in the court?
Thank you, Mr. Attorney. Perceptions, because the work we do as judges, as courts, cannot be equated to a football match between two teams, where sometimes people win, sometimes it's a draw. There is no draw in a dispute resolution. There's a winner and a loser. And winners will celebrate. Losers will not join them. Losers will look for excuses why they lost. And so there are those murmurs that decisions are made on account of other considerations other than merit. there has never been any specific case, because then we would be having people before EACC and court. But that is not to say that these rumors are just rumors. If there are rumors, then we must find out what is causing these rumors. And I know in the strategic plan of the Supreme Court, they have identified interventions to address these perceptions. Training, they have talked about engaging each other, just as you have suggested, just talking and finding out where are these gaps that make people think that we are on the take. And so if I'm lucky to join the court, it is a conversation that I think can be taken forward as the court reviews its performance for the last 10 years. A conversation among ourselves helps. Like in our court, we talk about these things very, very openly, and we keep reminding each other that we are lucky, first and foremost, to serve in the second top court, in the Court of Appeal. And secondly, that the government has invested in us in terms, and the people of Kenya, in terms of our salary, in terms of our allowances and other benefits, that we should not be susceptible to any corrupt temptations.
Thank you very much, my lord. Moving on to another aspect on judicial independence. The threat to judicial independence, as you know, my lord, is usually understood and associated with external pressure from either the executive or the legislature. But having served in a collegiate court, you are also aware that there can be pressure from within the court itself and the colleagues you'll be working with. How have you balanced, on the one hand, the aspect of collegiality, and on the other hand, your independence as a judge in making decisions?
Thank you. Independence of the judiciary, all the time when we talk about it, the focus is on the other two branches of government. We also ought to be independent of each other. There may be instances where a colleague tries to influence you, or even where a member of the family or any other person out there, a friend. In a collegiate court, you have to be very open with each other. You have always to disclose your interest. The interest that you need to disclose ought to be something like, I dealt with this matter at some point only on a preliminary stage. It cannot be a disclosure that I've been approached by so and so, because in that case, then that will be the end. And so there ought to be openness as a college of judges to discuss things openly.
And how, my lord, would you deal with that aspect, bearing in mind that you're only 7 judges and you may be compelled on occasion to invoke the doctrine of necessity? So you're conflicted on the one hand, but the doctrine of necessity dictates otherwise. how would you deal with that sort of situation?
The doctrine of necessity, if we were to go back to history, its origin in common law, that you are permitted to commit a crime in order to save a worse risk or calamity. It was developed to save situations. And the examples that are given are many. For instance, if it is illegal to drive without a driving license, but you have a patient who is in an accident situation, somebody who is going to die involved in an accident. So although you have no driving license, but to save this life, you will break the law by driving this patient to the hospital. That's necessity. And the same principle, therefore, applies, so that although we have this conflict, but we are only 7, the fact that we know, the fact that you have disclosed it, we will now keep an eye on you as we go along.
Thank you very much. And finally, Honorable Judge President, again, in the event that you are appointed to this court, you find yourself being invited to a workshop, an induction and bonding session with your colleagues, the other 6 judges of the court. And you're invited to make a contribution to the agenda for that bonding workshop. What items would you want to see, would you yourself suggest for that very first meeting, where you're going to have an opportunity to discuss matters of the court with your colleagues? What 1 or 2 items would you have on that agenda? And what would inform that, my Lord? And that would be all from me.
Thank you, Mr. Tony. The first session is bonding and orientation. From what we have been discussing regarding that code since this morning when the interview started, I'll have agenda to do with the jurisprudence. How do we make sure that our jurisprudence is respected? How do we make sure that this court remains together as a collegiate court? I'll also put in that agenda the issue of dissenting opinions, and finally the timelines for delivery of judgments and rulings, because I get the sense sometimes that from what I read in the media, that although the timelines for delivery of judgments and rulings is 90 days according to the Supreme Court Act, and I think the rules as well, that there are judgments on notice is a practice that perhaps, if it is existing, is a practice that needs to be looked at again.
I am most obliged, my Lord. That'll be all from me, Chair. Thank you very much.
Thank you very much, the Attorney General. Now is the time for Commissioner Kishohi to continue the questioning.
Thank you, Chair. Judge, good morning again.
Good morning.
I want us to focus on 2 issues. I'll be very brief. As the state officer in the Supreme Court, and I want us to reflect on Article 10 of the Constitution on national values and principles of governance. And one of the principles, the values under that article, is the promotion of national unity and patriotism. In your view, how will you promote that value as a state officer, as a judge in the Supreme Court? National unity and patriotism, those two.
National unity, patriotism, and you are a judge, it can only be through your judgments and your decisions. They should reflect that you are truly a patriot, and they should also reflect that you are alive to the need of having the country united.
Mm-hmm. In the event of matters of public interest, national importance, does it matter?
Of course it will matter, because if we close our eyes in some of these matters, and remember last time I was before the Commission, I gave examples of decisions that we have made as a judiciary that have far-reaching consequences on the economy, on the development of this country. And so, yes, that will also matter.
Very good. Chair, I got something else. In this case, I'm focusing myself on the strategic plan for the Supreme Court 20 up to 2024. And two of the objectives there relates to the staff, enhancing staff skills and competence as one of the strategies that they need to realize between year 2020 and 2024. As a judge in that court, how will you be able to assist the court realize that objective, enhancing staff skills and competence? Two things you do.
The court has the president, has a vice president, has a registrar, deputy registrar, and the other administrative staff. But it's one court working together. Judges, including the president and the vice president, are equal. And being one family, we obviously have a forum where we can provide some of the solutions. And I believe the strategic plan focuses on training of staff, and also on provision of tools of trade. What do they need in order to deliver?
Okay. They also have, in the same strategic plan, a provision to provide a safe, conducive working environment. That's one of the challenges, and they want to address that within the 2020-2024 plan. How will you do that?
Safe, conducive working environment.
Yes.
I haven't been to the registries, and this is in relation to staff, but I know this building, you can't describe it as conducive, even for judges. It lacks basic things like washrooms. The registries are squashed. And so they have a strategic roadmap on how to address this. In that plan, they have proposed that the court gets its own premises, a building, where all the facilities, suitable facilities, will be available.
So how will you assist them get that?
If they haven't gotten already, it is really just to look for land. We did in the Court of Appeal through, of course, the Office of the Chief Justice and the Chief Registrar, and we got land. Again, to the Treasury, we got money, which we were meant to have started building, or design work is complete. So again, really it's just to get land, and even where we are sitting today can be land that can be used to build a proper Supreme Court.
Okay. Finally, Madam Chair, Honorable Judge, under the medium-term program 2018-2020, and this is about judiciary whole, there's a flagship program under Vision 2030. Are you aware about that program?
Vision 2030, yes, I am.
So why is that in terms of the judiciary under the medium term 2018-2020? Where are we?
I know there are three key areas in the medium term: the social, political, and economic. And the judiciary falls in political, not known how. And we have undertaken to ensure that the rule of law is realized. I can say that if I was to give out of 10, I would give 3.
3 out of 10.
Because a rule of law means that everybody is obeying the law. The law applies equally to everybody. So why I'm giving it 3 is that we still have people who do not obey the law.
Okay.
They do not even obey court orders. Hence 3 over 10.
Okay. Thank you, Chair. Thank you, Judge.
Thank you very much, Commissioner Gishohi. Now I would request Commissioner Koskei to ask his questions.
Thank you, Chair. Good morning, Judge.
Good morning, Commissioner.
Yeah, I have 3 questions. I wanted to pursue still on the issue of the value that you are going to bring into Supreme Court. You said you don't want to criticize the office that you are joining for obvious reasons. And you also responded to Macharia that I think you will work on the issues of speeding up the work of Supreme Court, which is commendable. I wanted us to focus now on your wealth of experience in administration. You've been in judiciary for 34 years. There's no office that you've not run in this institution, except some few perhaps. And therefore, I really wanted to know what other value that will boost delivery of service in Supreme Court, on the side of your wealth of experience in administration.
Thank you, Commissioner. I emphasize again that from my time as a magistrate, working in this same building, working in various courts in the country, in the High Court, and currently in the Court of Appeal, where I've been privileged to lead my colleagues. I believe in one thing, in consultation before decisions are made. I have worked in these courts with people who are senior to me. When I worked in the only place I worked in the High Court where I was alone was Malindi. Thereafter, I worked in Meru under a judge. I worked in Nakuru under a judge. And I worked in the Court of Appeal under the President. And it is normally my approach to contribute whatever knowledge I have on how to improve the administrative aspect of the courts. So for instance, I worked in Nakuru under the former Chief Justice and 2 others. So I was actually again the mono, as was said earlier. But of course, because of my background, I was able to agree as a team with my colleagues that certain things ought to be done in a particular way in order for us to maximize on our service delivery. So it's the same thing, God willing, if I'm honored to go to the Supreme Court. the same approach, that you look at the gaps, and if there are gaps that you can be able to fill, then you make a proposal and it is owned by the rest of the team.
Thank you. My second question is on how we can position judiciary in helping the country in economic development, economic growth. And as you are aware, the executive are trying their best. They are trying to loosen their procedures and regulations, enhancing security to ensure that this country becomes attractive. And Parliament also are trying to, to enact laws and statutes that will also speed up investors coming in and, to help us in sorting out most of these social problems that we have. Now, coming to judiciary, having a wealth of experience in judiciary all along from district magistrate to Court of Appeal, and now, God willing, you'll be in Supreme Court. In what ways can, judiciary and even Supreme Court help this country in trying to make it attractive to investors, in making it be very attractive to businessmen, so that all these unemployment problems, the challenges that we have, will a bit subside or be brought down, so that the country can have rapid economic growth?
A survey that was conducted by World Bank some 2 years back, I think, on ease of doing business, has shown that Kenya has risen from where it was in Africa and in the world. In Africa, I think we've gone down from, position 4 to 6. But across the 190 countries that were surveyed, Kenya has gone up quite a bit. And that rating has been credited on the work that the executive has done through the Office of the Attorney General, the registration processes and all that, the laws that Parliament has passed, or the two houses. And then, of course, there is a bit of indictment again on us in that report. One, that it takes forever for cases to be determined, and two, that the orders we give sometimes, be it an injunction regarding land where an investor wants to put his money, sometimes are given ex parte, delaying mega projects. And so there are questions that we need to address. And this is what I keep saying, that it is not good to have an efficient executive and efficient legislature and the most inefficient judiciary by the way we distribute resources. The judiciary is, to use this strong word, retarded because of the way it is treated. For us, all of us to march, the three arms, to march together in unison to achieve these goals, there is need for equity. If the executive gets nearly 1 trillion in its budget, of course, the executive is very big. Parliament gets 37 billion, and then you give judiciary 17 billion. Then you can see why we cannot walk in the same at the same speed.
So you're saying that it is lack of finances that is
just support generally. just
so that they can
just support, for
Yeah.
instance, not just finance. I mean, right now we are not able to, in the Court of Appeal, and I believe other courts, to function to our optimum because of the number of judges.
Okay, thank you very much. My last question is on regional balance. It's a very emotive issue in this country. People think tribal, people think region. And I must say that you have many people in this country who have faith in your leadership and your work as a judge. I received so many when you came for this interview, and it was overwhelming. My Facebook, my Twitter, saying that Ouko is the man. And when we unveiled the candidate for Chief Justice, also my friends from east of the mountain were very excited and saying thank you for delivering a seat for us. And thereafter, even yesterday, I got a lot of calls, messages saying that it is our turn, our region has to get, you have 3 today. You have Justice Ouko, you have Selgon, and you have Yano. You have to give us 1. Talking as now the West. And when you look at Article 232, it says that we need to ensure that regional balance, diversity, communities should be involved in it. How do we do this? Because it looks like it is just written, but it has become very difficult to implement in a way, because to prescribe a way of doing it seems not to come out. But everybody, in every function, in every state, people talk about it. How do we do it so that our people in this country get to know that we look at integrity, we look at competence, and then we look at suitability as is stated? And how do we ensure that we really sort out this issue of regional balance that is coming out in everywhere, even in Parliament when they are electing even chairmen, everywhere? How do we, what is your view on how to sort it out?
Diversity, ethnicity, our turn to eat is a very, very dangerous disease. Very, very, very dangerous. And people say in our region, I really don't have a prescription. All I know is that we are very deeply tribal, deeply. Even in this commission, deeply tribal. I want to leave it at that.
Thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Commissioner Honorable already, please wrap up this session.
Thank you, Chair. Judge, I don't have very many questions. I want to start off with one question that is simple but may also be quite hard. What I want to ask you, how do your colleagues in the Court of Appeal describe you?
Well, yeah, you correctly say difficult. Maybe from rumors, because people describe you, not to your face. Of course, they say nice things for you to hear. They say many nice things, like Commissioner Macharia said, humble, you are a team player. But behind me, they think I push them too hard. I'm a slave driver. and sometimes I go out of my way to seek results, and not just results, immediate result, excellent result. So I don't know whether it's a good thing or a bad thing, but of course, sometimes I realize that I'm pushing them, and so sometimes I slow down and consult them.
Thank you for that honest and candid answer. The other question I want to ask you is whether you believe in mentorship and whether you take your time to mentor others.
I do, not all the time. I can say when I was in the High Court, whenever we had, in all the stations I served, students from the university who came to be attached to the courts, I would take my time, unlike my colleagues, to explain to them the processes of court, the way we dressed, the language we used, and that's something I did throughout. I don't see much of it in the Court of Appeal now, because we are hardly even introduced to the students. They come, they go to court, sometimes just in the registry. So there is very little mentorship opportunity. I mentor also in local schools. Last time I was here, I mentioned in the local school in my village in Usenge. I mentor students in schools. Mentor when I worked in Nakuru, and even in the Court of Appeal before I became president. I used to mentor students in St. Andrews, Turi, as well as Green States in Nakuru.
Thank you. Another question I want to ask you. Within the judiciary, there's been feedback that I have received as a representative of KMJA that we do not have a structured mechanism for seniors to mentor juniors. Now, looking at you, my lord, you have risen through the ranks from DM professional all the way to the Court of Appeal. You are sort of an icon that members, especially in my cadre, look up to. Now, I want to give you an opportunity to mentor in the air, a concept that we just learned of the other day here in the commission. A member of this institution who is currently maybe in the rank of resident magistrate. In your experience, what words of wisdom would you share with them?
We never get opportunities to mentor colleagues in a structured way, apart from occasional bumping onto each other and advising. But there's need, as KMJA in the past, the current one I can't describe. In the past, there were opportunities even to, have gatherings where you get senior judges, excuse me, who would come to talk to magistrates and encourage them to show them that it's possible. And so on this occasion, since I do not have any other platform, and as you've requested, is to tell that RM that I was a DM, one level below him or her. And through hard work, through integrity, and through being very sensitive to the people you serve, you can rise. You can rise and be anything in this judiciary. Just keep to a straight line, do your work, and you will reach.
Thank you very much, Judge. I wish you well. Thank you, Chair.
Thank you. Thank you, Honor.
Your Honor, this is the end of this interview, and on behalf of the Honorable Commissioners I want to thank you for coming for the second time and engaging with us. And we wish you all the best. I don't know if you have anything to tell us, Your Honor.
Really just to thank you, Chair, and the commissioners for this second opportunity. I also want just to wish you all the very best as you come towards the end of this very grueling exercise. If it has drained me this way, I don't know how much you have been drained. But I pray to God that you still maintain some strength as you conclude this very, very important exercise. Thank you.
Thank you very much, Your Honor.